Hello, I am Tamara Rogers, owner and attorney of Rogers Law Firm, an estate planning, probate, and guardianship law firm located in Carmel, Indiana. We represent clients in the Indianapolis, Indiana community and throughout the state of Indiana. We are at the beginning of a new year, and many of you may be interested in having resolutions to look at your financial affairs or planning things in your life. As you're sort of thinking about your finances and planning, estate planning is a very important piece of that. Estate planning is designed to explain to your loved ones and those that you care about how you would want your things to be distributed or handled if you are unable to make those decisions or if you pass away. The question today for Ask Tam, our informational session about a legal topic, is what is included in a will-based estate plan? A lot of people have heard of a will, which is legally called a last will and testament in the state of Indiana. But many people don't understand that a complete package, that's a will package, includes several legal documents that are tailored to your specific needs. And I'm going to review what those documents are here. The first is the last will and testament, which most people have heard or are familiar with, seen one in person or on a movie. And that is a document that explains to your loved ones or those that you care about how you wish for your personal property to be distributed after your death and who you want to be over managing your things, your property, your cars, your bank accounts, your collectible items after your death. The other piece of what's included in a will-based estate plan package that we offer are the power of attorney documents. There are two different types of power of attorneys in the state of Indiana. Think about two categories: power of attorneys for your health and your wealth. One, the healthcare power of attorney designates who or what group of people. Usually it can be a single person or it can be a co-power of attorney or a primary and a secondary power of attorney, for example, of who you want to make decisions for you if you are unable to make decisions for yourself. And you could be unable to make decisions because of a disability or long-term incapacity, or it could be a temporary medical condition where you're unable to make those decisions. The second type of power of attorney is over your wealth and your finances. And so, again, if you're alive, but you're unable to make decisions for temporary reasons or for more long-term reasons, who would you want paying your bills, managing your investments, being able to transfer funds from different accounts? The power of attorney that you include over your health issues does not necessarily have to be the same person that is over your wealth. Sometimes they're different people depending on what their strengths are and their relationship with you. Another part of a will-based estate plan that we provide at Rogers Law Firm is the living will, also known as advance directives. And it has the word will in it, so it's sometimes confused with the last will and testament, but it's very different. The living will, also known as an advance directive in the state of Indiana, explains what actions you want to happen medically if you are unable to make decisions for yourself or care for yourself. So these can be hydration by a tube, ventilation, nutrition, things like that. So life-sustaining measures that you may have very strong opinions about. Another piece that is very important that we include in our will-based plans If you have children or you are adopted children or your biological children, it doesn't matter. Who would you like to be guardians over them if you do pass away and something happens to you? If you do not name a person and there is no one there who legally goes to court to get them, your children will be in the custody of the state of Indiana until those issues are worked out. And most people do not want their children in state custody for any reason whatsoever, because it's already traumatic because their parent passed away. And so imagine being with strangers in state custody. And so a lot of parents want to get an estate plan mainly to protect their children and to clearly state where they want their children to be and who should care for them if they pass away and their children are still minors, or if their children are special needs and need extra care. Another piece of Rogers Law Firm's will-based plan that we do is prepare final wishes. And so some clients have very specific opinions about if they want to be buried or cremated, where they want to be buried. And some clients even have already paid for prepaid burial plans and or burial plots. And so that information is also included in our will-based plan. And the final thing that we include in our will-based plan is we review your beneficiary designations for things that you have beneficiaries for example, life insurance policies, annuities, those sorts of things, to make sure that they comply with your wishes, also comply with Indiana law on how you would want those things transferred upon your death. So again, Rogers Law Firm, we're here to tailor your estate plan to what you want and what's best for you and your family. Some people choose to have a will-based plan, and this video was sort of to explain to you what documents and things are covered in a will-based plan. And so to review, there's a last will and testament, there's a power of attorney for health and wealth, there's living will, also called advance directives. If you have children, guardianship documents over whom should care for them if something happens to you and you pass away, and your final wishes about burial, cremation, etc., and a beneficiary designation review. So I hope this gave you some education on what's included in a will-based plan. We help clients throughout the state of Indiana, so we hope that you share this video, subscribe to the channel, and we just want you to have information so you can make the best decision possible for you and your family. So remember that estate planning is a part of that, creating a legacy and part of your extended financial plan. You can contact us at 317-343-9406. Again, Tamara Rogers, Rogers Law Firm, where we help you plan for all stages of life. Take care.